Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their
when we
court.
started 110 years ago.
We're getting commentary on the case. Dati mihi Anglican please, verbus Latino. I didn't ask you to interrupt me.
Is that correct?
Literally not true.
Oh, for crumb's sake.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I say good morning. I should almost say good afternoon. I apologize. I apologize. I'm so late today. This has been the most Monday of all Mondays. It's gone scawampus every which direction. All right, hang on. I need somebody to be in charge of the internet. Someone who's responsible and is this working? No. Buttons are not working. Paula Mack, congratulations, you're it. Tag, you're it, Paula. Everything I pre-related worldwide is your responsibility. And I've already taken care of the big issues this morning, so it's all good. We've got construction guys right there working right next to my fiber line, and I'm super, super nervous. They're just waving ladders and hammers around. And it's crazy. Oh, man. All right. Jade, thank you very much. Happy Monday to the best channel. It's a great Monday. We're trying to secure some last minute deals into courtrooms. They have weird rules. Have you ever heard of a judge saying you can live stream the court case, but if you do, you can't have chat? Excuse me? What part of freedom of speech did you struggle with understanding? Was it the freedom part or the speech part? Or is it of? Yeah, about that. I'm trying to figure out. I've got calls into 11th Circuit down there in Florida, trying to get some clarification on this because no live chat rule. If you live stream, no live chat room. Well, I hate to break it to you, Judge. I hate to be the one to have to do this. But the Constitution is the foundational level. And if you'd make any rules that violate the Constitution, it's no bueno. It's no good. It doesn't work. RAV Florida Supreme Court. Yeah. Let's go ahead and make that argument. I don't know. I want to comply as much as I can. I think there's a way to work around it. I'm not sure if he wants a 10-minute delay or an hour delay or a day delay. But to tell people they can't talk about the trial if they watch it. You can live stream it. You can watch everything that happens in court, except for the jurors. But you can't talk about it. There's a problem there, and I think maybe there's a misunderstanding. So hopefully we got that cleared up. Denise Feldman Ursland, member for 41 months, OG. Also an OG, Paula Mack, our internet owner today, OG. Thank you very much. And guess who's almost an OG? And by almost, I mean so close. Drama Llama Mama, OG. We're going to count it. Also, Kim R, 16, 36 months, OG. All right, we are trying to get this sorted out, and I apologize because while I'm digging and doing all my research and emailing and texting and leaving phone messages and not saying mean words because I didn't want to burn any bridges this morning. I know. May the bridges we burn light our path. It doesn't always hold true. Sometimes it helps to be kind. So while I'm doing this, my phone just starts blowing up, and one of the buildings I manage internet for is just sending alerts offline, and then I get a text message. The internet's down here. Do you know what? So I jump online, and sure enough, everything's down. And I go through my notes, and apparently like 2 ISPs ago was the last time we updated our notes. So I'm calling this company and saying, you need to fix your internet. And like, we don't even do service for you guys. Like, you don't pay us or anything. So it got a little tricky, and I managed to fix it remotely by rebooting some firewalls and stuff through a dial-up. It got hairy. Let's put it that way. It got hairy. But the internet is back up there. Paula Mac, if it goes down again, next time it's on you. So let's get that fixed. Tisha, thank you, thank you for the sunshine. I need that this morning. All right, we have to sing happy birthday before it's tomorrow, and then we miss everything. The internet's boom. Yeah, it's so bad. All right, a couple people to sing happy birthday. Laura's birthday was yesterday, and then Betty, Karate Cat Mom, and T May all have birthdays today. So all of you, wherever you are, join with me and start singing happy birthday to these wonderful people. Do this by standing up, taking a breath, shoulders back, project your voice to the back of the room, blend your voice with the neighbor, and warm up with me if you will. La 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 la. Oh, Laura's today, the others are yesterday. Okay, got it. Happy birthday to you. Happy birthday to you. Happy birthday, dear Laura, Betty, Karate Cat Mom, and T May. Happy birthday to you. Real drumming, just today only. Happy birthday to everyone who's celebrating their birthday today. Happy birthday. I realize there are a million places you could be and a million people you could have celebrated with, but chose to be right here with us. The privilege, pleasure, the honor is ours. Hopefully we can return that joy back to you, make your day just a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlap's house, and his grill at Bob Evans. And Cracker Barrel. There you go. Woo! That's a lot of people. And as we continue that, I've got some more anniversary messages. Amber's mom, 3 months. You've been here longer. You're an OG. Amber's mom, 3 months. That's the youngest designation we've ever given out. Greener's member for 37 months, also an OG. Best 37 months I've had in the last 2 years. Appreciate the little stipulation, little add on the asterisk on the end. MoFan, welcome to the gallery. Couple months under your belt as well. Jade, member for 21 months. Happy Monday to the best channel. Thank you very much. Appreciate it. A couple of you might have noticed we were on. I taped a segment for Josh Ritter, Court and Confidential. I think he aired it yesterday. I was filming on Saturday, and he asked a question about the South Carolina via Chow case, which everyone's talking about. We watched it here live, and we finished the song. Air drums. My hands hurt. I can't pound the table anymore. Excellent. There we go. Happy birthday, everybody. And I'm sorry I'm late. It's been longer than 5 months. Leanne, OG, you've been around for a long time. Yeah. Anyway, so Josh sent me a message saying, "Hey, I've got this question. Can you answer this question for me?" It was from
Happy
Jim.
Birthday. You look good.
Thanks, Judge Fleischer. It was from Jim in the Marshall Islands, and Jim had this question about it. And so I'm like, if I'm going to answer this question, I've got to be somewhere. Last time I did this, I was standing outside the USS North Carolina battleship in Wilmington, North Carolina, on the coast. So I'm like, if I'm going to do this again, I've got to be somewhere cool. And so I'm like, well, it's the South Carolina case with Rick Chow. I'm like, the only thing I've got is a Shell gas station. And lucky for me, they just built a Shell gas station. And by built, I mean it's done. Everything is up. Pavement's in. The parking's been striped. All the gas meters have been measured. Like they've done the little, is this actually put out a gallon when it says a gallon? They've done all that. So they've got brand new stickers. Everything's in place, but the store has not had its opening yet. So there's no customers. So I have this massive Shell gas station, the outside anyway, because I can't get in. I mean, even the cameras are up. Bar sucks anyways. To myself to film this little clip, which ends up being like a minute and a half. So I find like an angle where I can have like the Shell in the background. You got all the pumps and everything, and because Rick Chow had a Shell gas station as well, and so I proceed to record the video. Well, I proceed to start recording the video, and I mess it up. 37 times I messed it up and started over. Then I sent it to them, and they're like, "Oh, no. I'm so sorry. I forgot to say vertical because I filmed it landscape." I'm like, "No problem. I'm still here at the Shell gas station. I'll just reshoot it vertically." And I won't tell you how many more takes it took to get it right before I sent them one that I was happy with. And by that time, the sun was in my eyes. I had moved so many times because I was standing in the shade of one of those lights, like the big parking lot lights over the truck parking area. And so it shaded my face perfectly, but it was still in full sun. I had to move like several times as I filmed this, but it was fun. And so a big shout out to Josh. That was a lot of fun, and this channel's just amazing. Yeah, it was it took more times. It took more times to get it right. Should have taken Little Miss, and she could have directed and filmed. I did take Little Miss, and she sat in the car in the air conditioning and just waited because it was hot. It was almost 100 degrees out there. It was not dusk. It was probably 3 o'clock in the afternoon. All right, we have a phone call. I have to plug it in. Hang on.
Call from Angela.
Hello, Angela. Good morning. Happy Monday. How are you doing?
Good morning. Happy Monday to you too and everyone else. It is great week. The Cup starts this week.
What does?
World Cup.
Oh, I've watched videos on that. I can never get the clapping and the stacking done right. But the guys that do it fast, that cup challenge is amazing. And they can do like a huge tower. It's like stack it. It's impressive. I might watch a few more videos. It's World Championships for that?
Yeah. World Cup, as in football World Cup.
Not the cup stacking?
No.
Oh. Is that why
the World Championships?
Is that why everything in every store everywhere has USA and red, white, and blue printed all over it right now?
Yes, that's why Coca-Cola even has all the teams that are this year in World Cup. Okay. People are even doing challenges like let's see if we can get all the countries. Like there, I see people buying like stacks and stacks of Coca-Cola to just find every country. Stacks of boxes of Coca-Cola cans.
It's all just going on eBay, right? It's just going on eBay next week once they sell out. I don't know. I'm probably going to get some. I think the Pepperidge Farms Goldfish USA edition. I'm probably going to get some of those. I think. Let's see. What did I get? The Twinkies. I think comes in USA edition. You can buy those because they never go bad. You can save those for like decades. Like next time there's a World Cup, you can probably break them out. They're still fresh. So.
Yeah, and you wonder why that's banned in Europe and the rest of the world.
You're just jealous. We have the food that will last through the zombie apocalypse.
There is actually a story here in regards to that, but coming from Sweden.
No, it's pretty bad. Cockroaches won't eat it.
Touching that.
It's bad. Twinkies are so bad for you. Not a sponsor. Thanks, hostess. But anyway.
Actually, I have a reason why I'm calling, and that is if you're in St. Louis area, there is a huge coffee pot by one of the stadiums where the World Cup is going to be hosted, and it's a free coffee. If anyone is in St. Louis area near the stadium, go ahead. It's a really good coffee.
They
it's
just
a
have like
Boston coffee.
a massive cauldron. You just dip yourself some and call it good.
It's I don't know what that is.
Like a cauldron, like a witch's, the big bowl that witches cook on the fire and stir and put the eye of newt and everything in.
I don't know how they cook it, but I do know that But this is really good coffee. This is a Turkish coffee. It's really good, so I recommend 110%. The team brought it. The team and the fans brought the whole can. So it's literally one huge gold can, and in it there is coffee, and you can get coffee for free.
It was like cooked like weeks ago, I bet.
I don't know.
I don't know. Well, if that's your thing, I don't drink coffee, so I'm good. But I'll pass on it.
But you're in South Carolina, so that's.
North.
I don't know if you guys have any. North, sorry.
Yeah.
North. I'm sorry. I don't know if you guys have any matches going on. So if you do, please, there is huge festivities. I recommend 100. For anyone in the chat, if there is World Cup anywhere near you, please, there is a huge festivity going on for a month. Please, I recommend 150%.
If there is one near me, can I go and film it?
Yes, why wouldn't you?
Live stream it?
Why couldn't you? There's going to probably be
streaming rights.
Copyrighted.
Yeah.
Yeah, music. But if you can get around it, then yeah.
Yeah. Interesting. I'm pretty sure we don't have any games being played in North Carolina because we don't have any football pitches. Is that what you call it? The field? The football pitch that doesn't have big, huge fire ant hills in it. So that would make the game just a new level of excitement every time somebody ran through one of those.
But the Let's Stadium is American football stadium, and they redid it so they can host it. They can host the World Cup in there.
Is that the one where the balls don't bounce? I saw a video on that where the players are trying to practice and they kick the ball up in the air, it lands on the grass and just stops. It's like the fake grass is the wrong type.
I don't know.
All right.
I don't know, but it is in our favorite state, Massachusetts. So.
Yay, sport. Go team. Everybody win. Enjoy the World Cup, which is hosted by the United States this year. So.
Yeah, and that's why I'm calling to go have fun this month. It's going to be huge fun. Fun. It's going to be parties and everything. I recommend 150%. It's free. Most of those parties are free, so don't worry about that.
Yeah, and don't worry about it being a super spreader event for Ebola or something. I think that's probably like 75%. Sure, that's not going to happen. So don't worry about that.
Yeah.
All right,
yeah.
Angela.
Okay.
Thank you for the call.
Bye-bye.
Good luck. Bye. She knows I was teasing a little bit. I lived in England for a couple of years. I know what football is. I know all about the World Cup. I was just giving her a hard time. Lindsey Ross, member for 15 months. Are we covering Wisconsin versus Lychwick? He is pro se and Waukesha. We're going to try to go that way because I'm still waiting for... Hang on. Well, I might have just got my answer. Still waiting for Florida to come through. No, that's not it. That's the wrong link. Okay, well, we'll wait. I think we might have to go to Wisconsin. Did RA find a house? I'm still in my house. Really wanted a boat wreck trial. We're trying really hard. Here's the deal. I need to know specifically what the rules are from the judge because we have been recognized as media outlet in Florida in a couple different jurisdictions, and that is something that took a lot of work to get into. And if we do something where the judge says we violate that, he can pretty much burn that bridge for us, which we don't want. So we want to comply with the rules, maybe learn the actual intent of what the rule is and see if there's a clarification somewhere. I've asked for copies of the ruling because I can't even see it. Hey, how's it going? What? Oh, okay. We might need that fixed too. Hang on, my contractor's here. Just 1 second.
Somebody just sent me a video of roaches fighting. I don't know who won.
Because he's the guy. When are we going to break for lunch, Judge?
Okay, that's going to cost us a fortune. Contractor is trying to fix part of our house, and he's up on the
Remember
ladder.
at the beginning
He's like, "Do
when
you
we
have any
started
wasp
110
killer?
years ago?
You have any wasp spray?" Yeah.
Hello.
All right, we're back. Florida be Floridine. Floridia. How do you say this last word? Floridine.
Even a blind
Is he bonded and insured? License and everything. Tiffany, the goal is to move eventually. We're looking at houses all over the country, but we've been here for 7-8 years. I said 7 and 8, even though I knew that it was 6 or 7, because I'm not going to do the
I got
thing.
a stubby little pencil.
Is Florida trial not happening? I know they keep changing the time. Steph, what's happening down there is they've set up the mics. They're all ready. There's going to be some motions being argued before, some last minute motion and eliminate type issues that are going to be argued before they do openings later today. They're supposed to start around 1 o'clock Eastern time, so about an hour and a half. And then it's anticipated that the openings will happen after that. So, well, yeah. All right. Wogger, member for 15 months. Can you please explain briefly what happened to the trial? We were watching on Friday. It's still ongoing, but we're out for some reason. Yeah, I can tell you. I got a very moving and heartfelt email from the wife of the victim. And she made a request, and I complied. She asked that it be taken down, and it's only the third time in our channel history that a family member has requested the video be taken down. And every time they reach out, I do comply with that. So that video has been pulled. Those 2 days of video have been pulled. But it was a very... There may be a situation where I get that request and don't comply. But in this case, I think it was the right thing to do. So... okay, I'm sorry. Come to Florida. I would, but you can't swim in the water down there. I mean, even your own pool, you have to strain it for alligators before you can swim in it. Would your family be moving if it weren't for your podcast career? I'm just wondering if too much exposure on your family is why you're moving. That's part of it, Gigi. Very much a part of it. But we also wouldn't be moving if it weren't for this, because it helps enable that as well. Do we ever find out the verdict? It's supposed to come out this morning, and I don't know what it is. I think we're going to just take a spoiler on that one. We need to get up to Minnesota, I think, is what we need to do. Because Florida's just taking their own sweet time. Okay. Let's see what this is. I think it's not the burn pit trial. It's not the boat crash. We've got Huron County doing something. Let me tune into this just for a second because I don't know what it is.
That if she were to post bond, that she would put on SoberLink, so I feel like that would be something that the court could look at, is to not being as concerned in regards to I don't know if it's danger to the community or whatnot. This Montgomery is clearly not a flight risk, but in regards to danger to the community, it seems that whenever if there's alcohol present, the allegations arise out of conduct because of that. So with the SoberLink, the court wouldn't have to be concerned about that. So just based on that, again, I would ask for a 5 to 10,000, 10% on something appropriate that could be posted.
Mr. Wallace, your position.
We need to change it up for the court.
Mr. Rakowski,
But
anything.
thank you. I'd argue bond before, Your Honor. We asked for that 500,000. I think was originally because of the incident that the court has the police report. The court had to read the police report, got a chance to look at the photographs. We introduced the photographs before, and that's why we'd ask for the court to consider continuing bond. I would note that the bond downstairs, Your Honor, is set at $50,000 cash surety in the underlying file for that matter, which is set for prelim tomorrow.
And the court recalls that relative to the original bond that was set. It doesn't appear to be a flight risk under MCR 6.120, but there's certainly a threat to the community, to the public at large. The defendant was on probation at the time of this alleged incident, at least down in district court where it's currently charged. The court had services in place through probation. There were no contact provisions. They were all violated, at least for purposes of probation violation. The court will reduce the bond, but it's going to be $100,000 cash surety. There's a significant threat to the community at large. That'll be all off the record.
That'll be all. They just paused. Boom. They're quick at pulling the plug. Okay, I'm sorry. I'm trying to find the link to what we're looking for here. I need Waukesha. Okay.
A new station alert has arrived.
We're struggling here. This is Monday all over again. Okay. Let's go to Judge Raquel West's room for a minute. She's in 7. It's awfully quiet there too. People are moving a little bit, though. I love that Courtney Company will use his phone as friend. Yeah, that was awesome. Josh is amazing. The whole crew over there is just incredible. They're booming. I don't know what number they're at, but they should, if not very soon, they should have already hit 100,000 subscribers. They're going to be there in no time. Let's see. Here we go. I'm trying to find the Kevin Lychwick trial. Doesn't look like it started yet. Did somebody say it started already? All right. You guys just enjoy the quiet. What case were you following next? Well, we're trying a couple. Let's see. Red Pen, your battery died. Oh, no. You know what I did over the weekend? I'm going to tell you because you didn't ask, but I want to say it anyway. I shopped for caviar. Those of you who watch the podcast know that that's something that we're going to be doing here either this week or next. I think there's going to be no podcast this week, but next week I think we'll do the caviar podcast. And I've learned that some people recommend you just take like a Lay's potato chip and some sour cream, and then you put caviar on it. And other people say you need like a water cracker and some whipped cream cheese and caviar. I have plenty of Lay's potato chips and sour cream, but caviar doesn't go bad apparently. I don't know. I'm going to try it. And I just don't know. I've learned that you can't call it caviar unless it's actually sturgeon eggs, but everyone still calls it caviar, like online. Like, it's like salmon caviar. I'm like, no, that's salmon eggs. I've used those for fishing. Let's see. That sounds so redneck. Lay's potato chip, really? Hey, if I'm eating caviar from something called a lumpfish, I think Lay's is actually stepping up a class level or two. Anyway, Amy, we're trying to find court right now. The trial down in Florida, which we were really, really hoping to go to, we're just waiting for responses from Florida, and they're not being very proactive about that. Let's see. So we're waiting for a response there. The judge has apparently issued a rule that you can live stream the trial, which is normal out of Florida. It's a sunshine state. But if you do, you can't have live chat. Which basically means I just have to turn chat off. So it would just be me talking to myself with nobody else. And you'd all just have to text me on the burner phone. And then I'd guess respond to all the messages as fast as I could. What happened to the trial in Georgia? The victim's wife reached out to me and we had a little conversation. And she asked that I pull it down. And she has very valid reasons. That case, we saw something in that case that we normally don't see. And the victim's wife was featured in that video in a terrible time. So the body cam was pretty rough. So we went ahead and complied with her request and pulled it down. I think it's one of those Mondays for many, definitely for me. Okay, let's see if we have any other. If anybody else is actually doing anything. I know Judge Dad was live earlier this morning. We might be able to jump to him while we wait for court to start. Judge McNally. Judgment Valley. That was close. Judge Michael McNally. Still missed it. Judge Michael McNally. There it is. There he is. Bingo. Found him. He was live this morning. He's got some civil stuff coming up in a little bit. He was live 17 minutes ago. Let's jump in and see what his morning went like.
Well, Heather, that's down to $250. Why don't you go down and they're going to give you a printout, okay, as to your payments. Okay? Go right down to the criminal department and they'll give you a little printout. Okay? Thank you. Mr. Ramirez, I want to see you, sir. You're going to have to turn some lights on there. I feel like you're in a dungeon or something.
He may be.
Oh, I'm in the truck, semi-truck. Sorry.
Okay, that's all right. People against style.
I'm in the dungeon truck.
Ramirez Jr. 26W842791. Your name?
Alejandro Ramirez Jr., Your Honor.
Did you pay this ticket?
Yes, I paid the
Park.
Ticket number 25.
Ticket in Allen Park.
Yes.
You better hang on. When did you pay it?
Friday. I got 2 confirmation numbers.
Right. Okay, so they probably there's a warrant and lien for you. I just wanted to make sure they take it out. But if you paid it Friday, it's probably out because my lien history here was run on June the 1. So anyway, you're going to plead to impeding traffic here, true?
That is correct, Your Honor.
This is a commercial vehicle. So to that charge, impeding traffic, commercial vehicle, responsible or not responsible?
Responsible, Your Honor.
I accept the plea, commercial vehicle, 180, speeding's dismissed. You're all set. You're going to pay that today, right?
That is correct, Your Honor.
You can go right on 33court.com with your case number and take care of that. Best of luck.
Okay, quick question, Your Honor. What would be my case number for this one? Because I don't have the ticket, so I could write it down so I could...
Write this down. You got a pen? 26W.
Yes. 26W.
842.
842.
791.
791.
Okay? Good luck.
Yes. Thank you.
Thank you. Do I have Timothy Whittle here?
Greeters,
you had a
thanks for
lawyer
getting
on
this
this,
for
did you not?
Well,
okay, so we're going to have to wait for your lawyer. Do I have any civil cases ready? He's got other things going, so just give him a minute, okay? Do I have any civil over there? Morgana Phipps, 26W842-785. Come on.
Might have to get smaller here in the corner.
Your name?
Yeah.
All right, so this says you're going to plead impeding traffic,
Yes.
improper turn accident, minor damage, no injuries. Is that what you're going to do?
Yes, sir.
To that charge of impeding, responsible or not responsible? Responsible to impeding traffic?
Yes, sir.
He was
That's
guilty.
0 points. Is that what you plead?
Yes, sir.
I'll accept the plea. 195 is your total, and the improper turn's dismissed, okay? Good luck to you.
Do I pay?
Right down the hall.
Okay, thank you.
Thank you. Look, any civil, what's civil?
Not for 9 o'clock.
Do we have anybody here on any of those, Linda?
Ellen Stone was here on the first case on your docket, but we don't have the attorney yet.
We need
Oh,
attorneys.
they just signed in.
Can you
Hey,
guys give me that file?
I'll bring them in
Give me
right
that.
now.
I think I gave you the motion, right?
We're going to jump to Judge Webster
You know, the prosecutor,
and
the court.
Jay Regier.
How am I supposed to do anything with a piece of paper with you out somewhere in the country? Where are you? Are you in the parking lot?
You guys, we were supposed to have court.
I know what the
We're
deal
gonna back
was.
up.
You were supposed
We're
to
gonna
take that
back
proof
up.
of
Hang on.
insurance.
Let's see when he starts here.
Plea of no contest.
Agreed upon disposition, counsel?
Yes, Your Honor. At the time of sentencing, the
He looks
agreed
so grumpy.
recommendations
They're on the
are
bottom.
that there be no fine requested, that the court order court costs for the court to determine attorney fees, a probation fee, 6-month controlling sentence, 1-year reporting probation, and have that probation with his current probation with community corrections, and that the parties will be arguing whether this would be consecutive or concurrent to the case he is currently on probation for with community corrections.
Thank you, Mr. Patterson. Mr. Baca, is that consistent with what you're thinking?
Yes, Your Honor, that is correct.
Mr. Graham, have you been hearing us talk?
Yes, ma'am.
Does that sound consistent with your understanding of the agreement?
Yes, ma'am.
Your attorney says that to the sole charge of criminal trespass, that is remaining on property in defiance of an order of the owner to leave. You committed criminal trespass. The charging document says on or about the 25th day of September 25 in Butler County, you, Michael Anthony Graham, unlawfully entered or remained upon land, navigable body of water, etc., to wit, 2908 West Central El Dorado, Kansas, by a person who knew they were not authorized or privileged to do so, in defiance of an order not to enter or to leave such premises or property, personally communicated to you by the owner thereof, to wit, Baumgars. This is a criminal trespass class B non-person misdemeanor, and you wish to plead no contest to it. Is that right?
Yes, Your Honor.
You don't want to admit the charge, but you don't want to deny it and take it to trial either?
That's right.
Is anyone making you enter this plea of no contest today?
No, ma'am.
You understand a no contest plea, even though you're not admitting it, gives up your right to trial,
Yes, ma'am.
and that you will be found guilty and proceed to sentencing?
Yes, ma'am.
Well, you won't be able to appeal your conviction. I'm not sure if I said that, but do you understand that as well?
Yes, ma'am.
All right, Mr. Baca, do you have a factual basis to support a no contest plea?
I believe I do, Your Honor. Your Honor, if we were to proceed to trial, the state would show that on or about September 25th of 2025 at a location here in Butler County, Kansas, that being 2908 West Central in the city of El Dorado, essentially the business of Baumgars, that the defendant did enter upon that premises on September 25th, 2025. And when he did so, there was a prior communication to him personally that he was not allowed to enter onto that premises. Again, that was communicated to him by representatives of that store on a prior date.
All right, I find the defendant has knowingly and voluntarily pled no contest to criminal trespass. The state has provided an actual basis to support both the charge and the plea. The defendant is found guilty of criminal trespass at this time. I will follow the plea agreement. Mr. Buckle, is there anything additional you had to say about that?
Your Honor, we would mirror those recommendations just to inform the court and give the only input in the state. The only term we did not agree to was whether this was going to be concurrent or consecutive to case 25 CR 290, as Mr. Patterson alluded to. State is asking for it to be consecutive. State's reasoning for that is he was on bond for that case at the time that he picked up this case, and that's the state's reasoning.
And Mr. Patterson, you have a response to that?
Yes, Judge. And the case that he is on probation for currently is case number 25 CR 290, Butler County case. He was sentenced on that case April 23rd, 2026. He did receive a 15-month sentence to the Department of Corrections, placed on probation with Community Corrections for 1 year. Judge, the thought process on the side of the defense is that this is something I hope not to ever have happen, but if by chance he was to have a probation violation, and if by chance he was to have it revoked, that going to prison for those 15 months would seem to be pretty harsh, so sufficient to, as punishment, rather than have him come back to jail, though, than spend additional time in Butler County Jail. Just would believe that releasing on parole at that time would be appropriate. So we're asking the court to run it concurrent for that reason, that if he ever serves, going to prison should be sufficient. Thank you.
Thank you. And what's he on corrections for right now? What's the basis of the charge?
It's a theft charge, Judge.
Theft as well. All right. Counsel, is that one of those thefts where it came about because of the number of thefts within a certain period of time? Or do you know?
I don't know enough about that.
Right, fair enough. Fair enough. All right, Mr. Graham, where do you work?
Martin Solvents, El Dorado, Kansas.
How long have you been there?
Nearly 8 months.
Okay. And do you live in El Dorado area as well?
Yes, ma'am.
Married?
Yes, ma'am.
Children?
No, ma'am.
Okay. At this time, I'm going to follow the plea agreement so far as there will be no fine. I will waive attorney fees. You will have to pay $108 in court costs. You will have to pay $60 supervision fee. Your sentence is 6 months in jail. I will suspend that so long as you successfully complete a 1-year reporting probation. I will let that probation run with your community corrections probation so that you only have to report to one probation officer. But you must comply with all conditions of your other case, and you must follow all the standard probation conditions. That brings us down to, will this be consecutive or will it be concurrent? Your counsel raised very good points on your behalf, but let it be further deterrent that these run consecutively so that you know that you have to complete your probation, or you're going to have to serve 15 months in the Department of Corrections, prison. Then you're going to have to come back to that county jail and serve another 6 months. So hopefully you won't have to serve any of this time. Hopefully whatever the problem was, it won't be a problem anymore, and and that you'll follow the law, because
No
that's going to be a
problemo.
condition of your probation now, as it is already on corrections. Anything else we need to address, Mr. Baca?
Don't believe there's anything from the state, Your Honor.
Anything further, Mr. Patterson?
Nothing further, Judge.
Very well, we'll be in recess. Mr. Graham, you're excused. Make sure you report to your corrections officer today to let him know what happened in court and what they want you to do next. Thank you, sir. All right, shall we let the deputy pick the next one, Mr. Patterson, or do you have someone in mind you want to call?
Judge, if we can go back to DeAndre Hadley to jail.
We're going to skip this one.
Mr.
We're trying to get
Hadley's
to
skip.
Bennett.
Endicott, who does not appear. Judge, this is a case where there's a motion for judgment on bond. I've not had any contact from Mr. Endicott, so I do not take a position on that motion.
We don't have him at the court.
Okay, that's not the one.
To how we should proceed on that issue, as it is at this time, the state does tender two motions for the court's consideration. First, that the motion for judgment on bond be withdrawn, and that this matter be dismissed without prejudice, with special emphasis on the without prejudice.
Special emphasis.
Mr. Patterson, any response?
No objection.
Well, both motions are granted then. And does he have a warrant you want to set aside too?
Your Honor, the state will defer to the court as to how we should proceed on that issue, as it is that is an order of the court, and the state does not consider it in its position to recommend the court overturn its own orders.
Well, if you're setting aside the motion to forfeit the bond, I think it makes sense to
And
set aside the
dismissing the
warrant.
case without prejudice, it would go away anyway, so I think it would have to be withdrawn.
All right, that will be the order.
Thank you, Your Honor.
So, you're welcome. So, Jennifer, please make sure that the docket notes reflect that the state has withdrawn its motion for judgment and that the state is dismissing the case without prejudice, and the court is granting those motions as well as withdrawing the warrant. Robert Bennett on the
There we go.
record in BU 2025 TR 2858, State of Kansas versus Robert Bennett.
In his
Please
best
announce
tank top.
appearances.
Jerry here on behalf of the same.
Did we take him up? No? Nope, we didn't. He's still here. Okay. Robert Bennett appears in person and pro se. Mr. Bennett, can you hear me?
Yes, Your Honor.
You are here on one count of operating a motor vehicle with expired registration or tags. You failed to appear on March 18th.
You were there. I was there. I was just late.
Yeah, I was going to say, and then you showed up late, so I set aside your warrant. What are you going to do about this? Sounds like... What are you going to do about this charge? Did you look into diversion? Did you get an attorney? Are you going to get a plea?
Well, you put it over due to the fact the police officer told me if I went and got registration the next day, you guys may just waive it, which I do have the paperwork with me right here, Your Honor, that shows I went and got, my wife went and paid it the very next day.
Where are you? You're not at the courthouse. You're not anywhere near the prosecutor, the court. How am I supposed to do anything with a piece of paper with you out somewhere in the country? Where are you? Are you in the parking lot?
You guys, we were supposed to have court.
I know what the deal was. You were supposed to take that proof of insurance to the prosecutor. You haven't done it, have you?
No, Your Honor.
What are you going to do about that? How far are you from the courthouse?
I am in Wichita at my job. I'm sitting outside.
And your wife is at your job site telling you what to do?
No.
She's not with you?
Who?
Your wife.
My wife is sitting right here next to me.
That's what I thought I heard her telling you, that you were there and
Bring
telling
your
you
wife
what
to work
say.
day.
and I know she's consistently been with you. I'm just surprised she's at your job site with you, but you need to start taking some accountability, Mr. Bennett. If you have the mental capacity to do it, you need to start stepping up on your own a bit.
If you have the mental capacity.
Okay.
Oh.
Well, Mr. Regier.
Well, I will
No,
take
wait,
any
wait.
charges.
Wait, you've had a chance to talk. Let's let Mr. Regier talk. Mr. Regier?
Your Honor, based off the state's notes at the previous hearing, it would appear the defendant raised identical allegations to what he is doing today. In the interim, which would appear to be approximately 2.5 to 3 months, the state is not in receipt of any additional information which the state would consider a legal basis to justify any oral motions, and so the state does not make any at this time.
Are you still at Boeing, sir?
Yes, ma'am.
He's at Boeing in a tank top?
I'm going to set this for bench trial, and you're either going to take care of this or you're not. You're not hiring an attorney?
No, Your Honor.
You wouldn't apply probably for court appointed if you work at Boeing.
No.
You didn't look into diversion. You keep telling me you're not guilty, but you don't put up the proof to the prosecutor who would dismiss it. You know that statute that the officer told you about? It gives you 10 days to get that proof to the prosecutor.
No, I did not know that, Your Honor.
Well, just remember, you're representing yourself. You're your own lawyer. Are you sure? Well, all right. I'm going to set this for bench trial. When's my next bench trial, Jennifer?
What is bench trial, Your Honor?
That means that the state's going to put on their evidence to prove to me, if they can, that you were on December 2nd of 2025 operating a motor vehicle without registration or with expired tag.
I was, and I'm not arguing that, ma'am. I was operating the vehicle.
Do you want to plead guilty to that today, then?
I mean, yeah, I'm guilty for it, Your Honor. I am guilty for that. I'm not arguing that point.
All right.
I did go get my registration the next day, though.
Okay. So
I am guilty.
So you're not telling me that you had registration on December 2nd. You're saying you got it December 3rd?
Yes, Your Honor.
Yes. All right. Well, let's go through this step by step. First of all, before I take your plea, I have to show for the record whether or not you understand that you can hire an attorney. Do you understand that you can do that if you want?
Yes, ma'am.
All right. And I would tell you that you can, if you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. But I don't think either one of us thinks that you're probably going to be able to with your salary at Boeing. Okay.
No, Your Honor, I won't be able to.
All right. So are you wanting to waive your right to an attorney and represent yourself, speak on your own behalf, and so forth?
Yes, ma'am.
Now, you've already told me you didn't understand all the law. Are you sure you want to be your own attorney?
I mean, This is different than we're here. Wait, come on, Candace, stop.
Who is this next to you?
This is my wife.
Ma'am, what's your name?
Candace, Bennett. Please just quit talking.
Go
Miss
Chiefs.
Bennett, are you an attorney?
No.
Then why are you giving him legal advice throughout?
I didn't. I just said it's different than court here.
Well,
Here in Wichita, it would have been dropped or dismissed.
All right. Again, you're giving him legal advice. Did you know there's a law that says don't give legal advice if you're not licensed to do so?
Okay,
Did you know that?
I apologize, Your Honor.
I was asking Miss Bennett. She needs to understand not to practice law without a license, where she can get into trouble.
I understand. I apologize. I won't say anything else.
All right. I don't want you giving him legal advice unless you're qualified to do so. Again, Mr. Bennett, you have the right to get an attorney. You've had it since December to get an attorney. You're sure you don't want to get an attorney, or at least talk to an attorney?
I didn't think I needed an attorney for this, so no, let's just proceed with court, Your Honor.
All right. So you live in Wichita, and in Wichita, they dismiss your insurance or tag violations?
To be honest with you, Your Honor, I have never had one, so I don't know. But my wife has had one, and it is just a fix-it ticket here.
Which means what? If you go out and buy insurance or tags, they'll dismiss it?
It's a fix-it ticket. They give us so many days to get the insurance, and then we didn't need insurance. You need or tags. I don't know, Your Honor. This is my first one, so.
Well, that's why I say I'll give you a chance to talk to a real attorney if you want one. I mean, you've had a chance. You've had a lot of chances since December, but I'd be willing to give you one more if you wanted it. I'm sure the state would object, but I'd be willing to give you one more.
I can get a free consult from an attorney, but I'd rather just go on with court. Let's just.
All right.
I will take the charges I got to.
So your work gives you a free consult to an attorney?
No, my work, no.
But somehow you have the right to a consult. You said you have some kind of insurance or some kind of method to do that.
No, I said I would find an attorney to do a free consult.
Oh, I see.
Yeah,
okay.
I would do my research and find one.
Okay, you wouldn't pay one, but you would go to one that would freely give you advice. All right. Well, are you wanting to do that? Or are you wanting to proceed today?
I would like to just proceed.
All right. Well, I find that you do know you have the right to an attorney, that you can hire an attorney. You know that I could appoint one, but not factually because you make too much money. And you've even talked about going out and talking to an attorney that would freely advise you, but you don't want an attorney. You want to waive your right and represent yourself. Is that all correct?
Yes, ma'am.
All right. Well, you do have the right to represent yourself. So I find that you do know what you're doing when you're waiving your attorney and that you're doing this freely. No one's forcing you to do it, are they?
Yes, ma'am.
Would you tell me in your own words if anyone's forcing you?
No one is forcing me to waive my attorney rights.
All right. Thank you, sir. I find that you've knowingly and voluntarily waived your right to an attorney. Now, I would remind you that you can plead not guilty and set this for trial at a later date. Would you like to do that?
No, ma'am.
You can plead guilty, admitting that you were driving without proper registration or tag on December 2nd of 25 in this county. If you plead guilty, and I accept that plea, you will be found guilty and unable to appeal the conviction. Do you understand that?
Yes, Your Honor.
It is an unclassified misdemeanor. It would go on your record. Do you understand that?
Yes, Your Honor.
And I don't know how strict your security clearance is there at Boeing, but it would be an unclassified misdemeanor, the lowest of misdemeanors, but it would be on your record. Do you understand?
Yes, ma'am.
Do you have any questions?
Am I eligible to suspend it?
There are some rules that would most likely allow you to expunge that, but it would be in time.
Can I expunge my conviction?
Yes, that's fine.
All right. You have one more choice to plead no contest, no loca tendere, no contest. You don't want to admit the charge, but you don't want to deny it and take it to trial. If you plead that, even though you're not admitting it, you'd still be found guilty, most likely, and you'd proceed with sentencing today. Any questions about that?
No, Your Honor.
Now, you could have applied for diversion, but we've talked about that. We started talking about that, I think, at your first appearance.
Yes.
All right.
All right, we're gonna be popping up to Wisconsin for this train wreck of a pro se case.
No.
Back to Waukesha.
Okay, so
where
how do you
Daryl
want
Brooks
to plead
was.
today?
Back to our roots.
Do you have any questions before you answer? Feel free to ask them.
Is this jail time or just a fine?
There is possible jail time. I don't know that I've ever seen it actually imposed on this offense. Usually probation is granted, but for this unclassified misdemeanor, there is a fine up to $2,500, but it's probably more likely 50, but I can't tell you what your sentence will be. It could be up to 2,500 in fines.
It could be
There
a
could be a
surprise.
jail sentence at least 30 days up to 6 months, but probation is an option. And like I said, I don't know if I've ever seen any jail time for this offense, but it could, certainly a first offense, but it could happen. You understand me?
Yes, yes, Your Honor.
Knowing all of this, do you have any other questions?
No, Your Honor.
Okay, so how do you plead?
Guilty.
You want to admit that you were driving December 2nd, 25 in Butler County without a tag? Was it without a tag, or you just hadn't registered your car? Or both?
Yes, sir.
Why don't you tell me in your own words what you did that makes you guilty of this?
Say that one more time.
Tell me in your own words what makes you
Or your
guilty of
wife's
this
words.
charge.
I was driving with no registration of proof of the tag.
Had you gone to the courthouse and paid for your tag?
Not to the courthouse, but to the DMV. Yes, yes, Your Honor. Tag office. Tag office.
Yeah,
Went the
she's
next day.
talking
My
again.
wife went up there and paid for it.
No, I'm talking about the date of December
Hello,
2nd,
hello.
2025. Is that
No,
today?
because it was when I got the ticket. It was nighttime.
All right, the ticket says 2151. Mr. Regier, help me out. That's what, 951?
That would appear to be accurate in military time, Your Honor.
951, Mr. Bennett? Does that sound
Nine-
right?
9:51 at night.
Right.
Yes. It was nighttime, Your Honor. I don't know exactly the time, but it was nighttime.
Okay. So I'm talking about 2151 or 9:51 p.m. Were you driving an automobile in Butler County, Kansas?
Yes.
Now, the officer's citation says you were driving is that a 2005 Ford Model F50?
Yes, Your Honor.
Did that vehicle have a tag on it?
It had a tag on it.
Was it a valid tag?
It was just expired.
That's
It was
no.
expired. Okay, do you know when it had expired?
No, Your Honor, I do not.
All right. And when the officer stopped you, were you on Highway 54?
Yes, Kellogg, yes.
Okay.
And he pulled me over due to a tail light, which that's not even on there.
Well, he would have probably given you an oral warning or just didn't charge you for that. Okay.
Yeah.
All right. Mr. Regier, that mile marker is in Butler County, is it not?
That is the state's information, Your Honor, between Andover and Augusta city limits.
Okay. All right. Well, I'm going to accept your guilty plea, Mr. Bennett, if no one's made you enter this plea today.
Nobody's made me.
All
Except
right.
maybe
And your
my
wife
wife.
keeps giving you advice. Is she telling you how to plead?
No, ma'am.
All right. This is your own free will.
Yes, ma'am.
All right. I do find you guilty as charged. Operating a motor vehicle without valid registration or with tag. Mr. Regier, recommendations for sentencing.
Yes, Your Honor. As a preliminary matter, does the state have leave to journalize a waiver of counsel in this matter?
Please do, and please, clerk, have the docket note reflect he's knowingly and voluntarily waived counsel as well.
Thank you, Your Honor. As a supplement to the record, the state's evidence would show that that the registration on the vehicle at the time of the December 2nd, 2025 stop had previously expired in March of 2025, as indicated on page 1 of the ticket. On the issue of disposition, the state is recommending a $50 fine, that the court impose appropriate court costs and a suspended jail sentence of 30 days, the minimum required by law under KSA 8149. State would further recommend a non-reporting probationary period of 6 months.
Okay, Mr. Bennett, you said you work at Boeing and you live in what town?
Wichita, Kansas.
Wichita. You're married.
Yes, ma'am.
Okay. And you have any minor children?
Yes.
How many?
I have 4. With 1 on 5, with 1 on the way.
Whoa. I have
All
four.
right.
I have five
Well,
with
I'm
one on the
asking
way.
that to determine appropriate fine, which I believe you can cover $50 fine and 108 court costs without too much trouble.
Yes, ma'am.
Okay, and I am going to impose the 30-day minimum sentence, but you will not have to serve that as long as you successfully complete your probation. I'm giving you a 6-month non-reporting probation. That means that you are on probation for 6 months, even though you're not going to see a probation officer. So don't violate your probation during the next 6 months, or it could be revoked and you could serve 30 days in jail, which could jeopardize that good job you have.
Yes.
Now, what are the conditions of your probation? One is don't violate any laws for the next 6 months. The second is to pay the total due of $158. If I order that you pay that in 30 days, can you do so?
Yes, I could pay it by this Thursday, ma'am.
Okay. Well, the reason I give you so much time is because if we don't get the journal entry filed in time, you may not be able to pay it Thursday. But hopefully we will. And I say we,
Okay.
the county attorney has to draft it. I have to approve it. It has to be filed and go to Topeka, etc. But hopefully it'll be done by Thursday. But to find out before you come over or do whatever it is you're going to do, you could even pay by online if it's filed. Call the clerk of the district court. Do you have something to take down the number?
1 second. Yes.
Okay, it's 316
867-5309.
Again, that's
867-5309.
70.
I have it.
All right. Call them and talk to them about making payment arrangements. And then the other thing is if you change address or contact information during the next 6 months, you need to notify the county attorney of what that will be.
Okay, and then can I ask you what address do you have on file?
For you, well, let me look. I don't want to say that over the internet, but I'll look.
Your Honor, perhaps this would be a better matter to be handled through the court clerk's office, given the nature of this proceeding.
Yes, that's an excellent idea because I don't want that going over the internet. So ask the clerk and she'll write it down.
We have our address. Okay, awesome.
She can get it to Mr. Regier.
The wife just can't.
Thank you.
And Your Honor,
giving advice.
for the record, is the court still ordering that the journal entry reflect that this matter should be paid in full within 30 days or some other time frame?
30 days.
Very good, Your Honor. Nothing further from the state.
All right. And what kind of bond did we have in this?
Your Honor, with
No.
all due respect, the state's information is that count one of the ticket and the information appears to be charged as an unclassified misdemeanor. Therefore, that issue is discretionary within the court's judgment.
Okay, and I'm not going to make him do that. All right, Mr. Bennett. Do you have any more questions? And I'll even let your wife ask now, as long as it's not a legal question, or as long as she's not giving you legal advice, I will let you both ask any questions you might have.
Do you have any questions?
No.
All right. Where to pay? Call the clerk of the district court at that number I gave you.
Thank you.
She'll answer all of that. All right. You're welcome. And keep your tags current, at least if you're in Butler County.
Okay.
Thank you, sir.
Thank you, Honor.
You're welcome.
Bye.
You may go. Appreciate it.
Your Honor,
Yes.
can we take up the in custodies real quick?
What was the name?
Right now I have Victoria Wilson Foster, and then I have 3 more in custody.
Oh, I'm so sorry. Yes. We need to take those up so you can get them back into
their cells.
But what did you say that name was?
Victoria Wilson Foster.
Wilson Foster. Okay, I was looking in the F, so that wouldn't work. Wilson-Foster. All right. We're on the record in BU 2026 CR 91, State of Kansas versus Victoria Amber Elizabeth Wilson Foster. Jared Regier appears for the state. The defendant, Victoria Amber Elizabeth Wilson Foster, does appear in person. in custody and pro se. Miss Wilson Foster, you're charged domestic battery, criminal damage to property, and driving under the influence. Judge Hart went over your rights and charges and so forth with you, and he approved your bond back at first appearance on March 18th. He appointed Darren Patterson as your attorney. Did you talk to Mr. Patterson about this?
Yes, I called his.
Okay, hold up. Mr. Patterson, I apologize. I thought she was pro se. You're her attorney, Darren Patterson, appearing for the defendant, who also appears in person, in custody, and with counsel, Darren Patterson. Mr. Patterson.
Thank you, Judge. Your Honor, this is a case where I did get myself in somewhat of a jam. I would tell the court also on this docket is Daryl Stevenson. And I have met Daryl Stevenson, discussed cases. During that, though, I did determine or find out that he's also the listed victim in this case.
Hang on 1 second.
It would appear to be a pretty direct conflict for me to
say. My proposal is similar to what I had in voir dire, and what I would like to do is add 2 sentences, those reading, standby counsel has been appointed by the court to assist with the efficient operation of the trial. The defendant, though, is still representing himself. That just clarifies the role of standby counsel here in this case. Any objection to that from the state?
No.
Mr. Lychwick, any objection to that?
You got standby counsel 1 week before a murder trial?
And we will bring the jury in.
Judge, I do have one thing I would like to raise before they come back in.
Sure.
Victim A's daughter, she will be the 3rd witness, so she'll be this afternoon. She has also requested to be present in the courtroom during the entirety of the trial proceedings and not subject to the witness exclusion order. Now that the jury is sworn and we are beginning with opening statements, I think that is probably the most appropriate time to bring this up. So under 906.15 sub 2 sub D and 950.04 sub 1 V as in Victor, B as in boy, I'm asking the court to allow her to be present prior to her testimony, and then she will be the remainder of the week.
Mr. Lychwick, what's your position on that request?
Oblivious. I don't know what to say.
Sure. The victim's daughter, as a victim representative, would like to exercise her rights under the statute and the Constitution to be present in the courtroom during her testimony. Ordinarily, there would be a sequestration order which would prohibit any witness in the case from being in the courtroom until they testify. After they testify, they'd be allowed to come in the courtroom and watch the proceedings. A special exception is carved out for victims and victim representatives. So her request is that she be allowed to be in the courtroom prior to her testimony. It would only be a couple of witnesses, though. She'd be the 3rd witness in the state's case, so it wouldn't affect anything too much.
Well, I mean, I understand her position. I have no objections.
Okay. The court will allow her presence then prior to her testimony, and certainly she's allowed to be present after her testimony as well.
Thank you.
Anything else from the state?
No, thank you.
Mr. Lychwick, anything before we bring the jury in?
Not at this time, no.
All right, then we will bring the jury in.
If not at this time, there's no time. The jury's here.
I do.
So Mr. Lychwick is his own lawyer, fired his lawyer right before his criminal trial, where he's charged with first-degree intentional homicide and hiding the corpse. He's been accused of shooting his roommate in the head and leaving his body under a tarp or something concealed for about 5 months. Eventually found, and now here we are, and he's pro se. And that would be illegal. Yeah, most states, Greeners, most states frown on that behavior. He's represented himself because he wants to get a new lawyer, but the judge said, "No, you're doing this just to stall the case. I'm not going to let you stall the case. There's already been too many delays already. We're going ahead, and you're going to handle it yourself. Good luck." But now he does have standby counsel. So, Selena, thank you for the gifted membership. That's awesome. Still can't see the emojis. I never see the emojis. Does he have his wife as second chair like Robert? Maybe that would be better. I'm not sure if he's married, actually. Sometimes not paying the cable bill has consequences. Right. That's all I got, Greeners. Just squares. Elbow counsel for the win. We'll see how active they are in this case. Judge Maas. M-A-A-S. I say Maas. Like Mas Tequila type. But
Thank you. You may all be seated.
this trial is sponsored by Hewlett Packard.
All right, ladies and gentlemen, before the trial begins, there are certain instructions you should have to better understand your function as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based solely upon the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. Do not begin your deliberations and discussion of the case until all of the evidence is presented and I have instructed you on the law. Do not discuss the case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communication. Do not use any electronic devices such as mobile phones or computers, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the parties. If you come into contact with any of the parties or the witnesses, do not speak with them. For their part, the parties and the witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you think might be useful to you in understanding the issues presented. Do not investigate the case on your own or visit the scene either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about the trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on the jury. Do not use a computer, phone, or other electronic device to share any information about this case. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I appreciate it's tempting when you go home at night or even over lunch when you check in with a loved one to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this matter. After the trial is complete, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, It could result in a new trial involving additional time and significant expense to the parties and taxpayers. You are to decide the case solely on the evidence offered and received at trial. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. And third, any facts to which the parties have agreed or stipulated, or which the court has directed you to find. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with a notepad and a pen. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. So you need to pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness and of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit their testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant caused the death of Carlos Maldonado. Cause means that the defendant's act was a substantial factor in producing the death. Element number two, the defendant acted with the intent to kill Carlos Maldonado. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Carlos Maldonado with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Hiding or burying a corpse. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant hid a corpse. Element number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with a purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. Standby counsel has been appointed by the court to assist with the efficient operation of the trial. The defendant, though, is still representing himself. The parties will now make opening statements. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Because the state bears the burden of proof, the state goes first in most phases of the trial. Attorney Tom Bosco, you may give your opening statement.
Thank you very much, Your Honor. Madam Court Reporter, or Madam Clerk, rather, can I please have the TVs on so I can project the PowerPoint? Thank you.
Yes, so nicely. As long as you plug in the HDMI cable.
Thank you very much. You may please the court. Ladies and gentlemen of the jury, this is why we're all gathered here today in this courtroom. For Carlos, to figure out what happened to Carlos, because the evidence is going to show that on April 14th, 2024, this defendant, Kevin Lychwick, murdered him. He shot him twice, once in the torso and once in the center of Carlos's face. This is a picture of Carlos. This was a much better day for him than April 14th, 2024. And I think it's important before we talk about the facts of this case to give you a little bit of information about who Carlos was as an individual in life before we talk about what tragically happened to him. Carlos lived in an apartment at 1512 East North Street here in Waukesha. It's actually just a stone's throw away from this courthouse. It's just down the hill. Some of you may have even driven past this apartment complex when you came to court a little bit earlier this morning. Carlos was just 55 years old on the day that he was murdered. He had goals in life. He was planning to start his own business, and he was very, very close with his daughter, Talisa. In fact, him and Talisa enjoyed going to different restaurants together. They enjoyed going to different Mexican restaurants. They enjoyed trying chips and salsa from every single Mexican restaurant that they went to, and that's how they would determine whether a restaurant was a good one or not. The relationship between Carlos and his daughter had never been better at the time of this incident, before he was tragically taken in this case.
You can judge an entire restaurant based on their salsa.
April 14th, 2024 is the day that the evidence in this case is going to show when this homicide took place. What you're going to hear is that on that particular morning, the evidence will show that Carlos got up that morning and went to a hardware store where he made a purchase. We know this because there was surveillance footage that captured him at this particular hardware store. We also know from his bank statements that he made a purchase on April 14th, 2024. We also know that after he finished his transaction at the hardware store, he returned to his apartment. And we know this because there was an apartment manager. Her name is Glenda Rose, and you're going to hear from her very early on in this case. She'll be one of our first witnesses. She actually witnessed Carlos in the garage area of the apartment complex cutting wood, and she actually greeted him. So we know that he made it back from the hardware store to the apartment complex where he lived. Unfortunately, after Glenda saw Carlos in the garage area, Carlos was never seen alive again. And despite many family members, including Talisa, his daughter, trying to figure out where he was, nobody heard from him. Talisa actually reported him missing, because it was out of character for Carlos to actually not contact his daughter. This was something that whenever Talisa called Carlos, at this point, Carlos was always very prompt in terms of getting back to her. So the fact that she had attempted to call her father and he hadn't gotten back to her, that was very suspicious. So there was a period of time in which several months nobody knew where Carlos was, nobody had heard from him. We were trying to find him. And October 30th, 2024 is when we made a very startling discovery.
I have to pause this just for a minute. Give me just a second to get this everything synced up the way it needs to be. Hold, please. We're trying to fix the audio because we've got some clips and clicking that needs to get rid of. 2, 3, 4, 5, 6, 7, 8, 9, 10.
Show is that there was a gentleman named Nathan Poley. Mr. Poley is a resident at 1512 East North Street, the same apartment complex that both Carlos and Mr. Lychwick lived at the time of this murder. And Mr. Poley was also a maintenance worker at that particular complex as well. And so what Mr. Poley was doing on this particular day was he was doing some yard work in the wooded area behind this particular apartment complex. So to give you a little bit of a sense of what this complex is like, this is a 2-level complex. There's units on the ground floor, and then there's a second level, and then there's additional apartment units on the second level. And then bordered to the back of that complex is a giant hill with some woods in the back area. So Mr. Poley was in this wooded area. He was doing some yard work, and he came across this blue tarp that you see depicted in this photo. And at first, Mr. Poley didn't think anything of this blue tarp. He thought it was just something that somebody had thrown away. But as he got a little bit closer to it, he made a shocking discovery. Underneath the tarp was Carlos's remains. And the tarp was covered, you're going to hear, in sticks, branches, and other foliage, almost as if the person who had set it there did so intentionally in order to hide what was under that blue tarp. The police get called because Mr. Poley reports what he found to the apartment manager, and the police are called, and the police respond to the scene, and ultimately Carlos is determined to be the individual whose remains were found under that tarp because dental records were able to positively identify him as such. His autopsy was performed on November 1st. There's going to be a medical examiner that's going to testify in this case for you as well. The medical examiner is going to tell you that she found trauma associated with Carlos, that she found a firearm projectile that was located attached to Carlos's scalp. There were entrance and exit wounds, and that there was a second projectile that was found under Carlos's torso area as well, and that he had an injury to his lower vertebrae that was consistent with a gunshot wound as well. Given the length of time that Carlos was missing from April to October, his body was in a very severely decomposed state. And unfortunately, we'll have to show you some pictures of that, but that's what happened in this case as well. So now we have this homicide. We have this body in the woods, and the Waukesha police are now involved, and they're investigating this. And they're at a disadvantage, you know, that's what you're going to hear, because of the length of time between when Carlos disappears and when he's ultimately discovered. So the police are really behind the eight ball here. They have to hustle to really uncover evidence and follow leads and make sure that they're identifying the person who's responsible for this. They start to investigate. They interview several people at the apartment complex. They canvass the area. And to be frank with you, for a while there, it wasn't looking very good. They were having some difficulty figuring out who did this, what were the circumstances surrounding this. They knew it was a homicide, but they didn't know who actually was responsible for this. And then what you're going to hear is they caught a huge break. And the break came in the form of a gentleman named Anthony the Freebray. And for the court reporter, that's spelled Lefebvre. Anthony, you're going to hear, was a resident at this particular apartment complex as well. And Anthony had a trail camera. And Anthony had been given permission by the apartment complex to build a garden in the wooded hill area behind the complex. And in order to keep tabs on this garden that he was building and to show the progress with family members, Anthony also set up a trail camera with the apartment complex's permission. And the footage on the camera dated all the way back to April 29th, 2024. So just a couple of weeks after Carlos went missing, and the evidence will show he was murdered on that particular day. The police came out and they saw the trail camera. And then they said, hey, we'd like to take a look at that footage just to see if there's anybody on that camera. And Anthony was very cooperative. He gave the police the footage, as you're going to hear, and the investigators reviewed it. And what they found on that trail camera was the defendant, Mr. Lychwick, walking around the area where Carlos's remains were found at very odd hours of the night. They saw the defendant carrying a white trash bag. They saw him suspiciously looking in windows of the apartment complex as if he was looking to see if somebody was watching what he was doing. He was seen in one clip, and you're going to see this as well as part of the state's presentation of evidence. He was wearing boots. At one point, he was kicking an item off his boots after he was seen walking in the area where Carlos's body was ultimately discovered. And he also was carrying some sort of tool. We don't exactly know what tool it was because of the quality of the video footage, but he's definitely carrying a tool as well. So the police now start to look into Mr. Lychwick because, you know, this is suspicious, right? And we're trying to see if this is the individual who's responsible for murdering Carlos. And once they start to look into Mr. Lychwick, they make many shocking and incriminating discoveries based on the evidence. So what Detective Stern and I did last week in preparation for this case is we sat down and we highlighted together, we came up with a list of what we think are going to be the most compelling pieces of evidence that you're going to hear. It's not all the evidence that you're going to hear in this case, but this is what we believe are the most compelling pieces of evidence that you're going to hear that point towards Mr. Lychwick's guilt in this case. First piece of evidence that the police found in this case was a note. The police went and got a warrant. They got a search warrant to search Mr. Lychwick's apartment to either confirm or dispel their suspicions that he may have been involved in this homicide. What they found, and you'll hear more about this during the state's presentation of testimony, was several documents that were handwritten with several quote-unquote operations listed on them. One of these pieces of paper, and you see it depicted here on this photo as well, contained information about an operation named Operation Slop Shop. You'll see it at the top of this exhibit as well. Specifically, as it relates to Operation Slop Shop, the piece of paper that was found in the defendant's apartment, where, by the way, he lives alone, he does not have a roommate, specifically names Carlos as a, quote, threat. There was an additional piece of paper as well describing another operation. This particular piece of paper indicated that Operation Slop Shop had been completed and that the threats from that first stop had been, quote, neutralized. There were additional pieces of paper as well found in the defendant, Mr. Lychwick's apartment as well. There were several other operations listed with many other individuals. The important piece is that those individuals you're going to hear had connections to Mr. Lychwick. So if the idea is that he didn't write the note, well, you're going to hear that several of the individuals listed on these notes, again, were connected to him. And then when the police were serving the warrant on Mr. Lychwick, at Mr. Lychwick's apartment as well, you don't always get Perry Mason moments, in the middle of trial. But this case, we actually have one of them. Because when the police were serving the warrant, Mr. Lychwick was given a copy of the search warrant for his particular apartment, a courtesy copy, if you will. What we do in Waukesha County is we try not to include victims' names in court documents because they have a right to privacy. We want to make sure that we're not unknowingly exposing their name or their information to the public for their own protection. So the search warrant that was given to Mr. Lychwick only said victim A. That's all it said, victim A. Yet, you're going to hear that when Mr. Lychwick was given a copy of that warrant and he looked at it, he exclaimed, quote, "Carlos Maldonado, I had nothing to do with that." At that point, we had not made public the fact that Mr. Maldonado's body was the individual that we had located on the grounds of 1512 East North Street. Oops. The evidence is going to show that only the killer would have known that Mr. Maldonado was the individual who was on that grounds when Mr. Lychwick made that statement. Another compelling piece of information that we found in this case was a storage unit. Now, during this investigation, the police looked into a bunch of different things as it relates to the defendant. We looked at his purchase history. We looked at how he was spending his money to see if there was anything that was suspicious as well from an investigative standpoint. Mr. Lychwick was on a pretty tight budget. This is what we found from looking at his banking records. He was living on SSI. Yet, the evidence is going to show that on November 1st, 2024, just 3 days after we discovered Carlos's remains at the apartment complex. Remember, he was found on October 30th. So just 3 days later, what we found is that the defendant drove all the way up to the Fox Cities area. He drove to the Kimberly area, and he took advantage of a 1-month free promotion to rent a storage unit in Kimberly, Wisconsin. We know that on November 1st, from what we found in his phone, that he was spending hours searching for storage units here in Waukesha County. We know, as I stated, he was on a tight budget. He was budgeting about $50 for gas. This trip, round trip to go from Kimberly back to Waukesha County would have greatly blown through his gas budget. Yet, we know that he went all the way to Kimberly, and you're going to hear from the representatives from the U-Haul as well, and he rented that storage unit. Okay? But he didn't rent it for very long, because 1 month later, after the free month had expired, and you're going to hear evidence to this effect as well, the defendant is seen on surveillance footage going back to the U-Haul storage facility and closing out that U-Haul unit that he had rented. Again, you're going to hear from an employee who helped him with that process. You're going to hear that the defendant was in a rush. He wanted to get out of there as soon as possible, and he cleared out the entirety of that storage unit as well. And then he made his way back to Waukesha County. What he didn't know at that time was that the police had obtained a GPS warrant for his car. So when he left Waukesha County and traveled to the Fox Cities, the police were following him. They wanted to see what he was up to. And so what they ultimately did was they effectuated a stop, and then they seized the vehicle that he was driving as well from Outagamie County all the way back to Waukesha County. And then they found the holy grail of evidence. The evidence is going to show in the defendant's vehicle. They found in the trunk of his vehicle, after they went and got a search warrant, by the way, so they seized the vehicle, but the police then went and got a search warrant. They searched the trunk of his vehicle, and they found, and you see it depicted here at the bottom of this picture as well, a 1939 Luger firearm. And the police did 2 things with this particular firearm. They're going to be very, very important in this case. The first thing they did is they packaged up this firearm, and then they mailed it to the state crime lab, in Milwaukee. And there's an individual who works at the crime lab by the name of Jessica Crawford.
She's a firearms and markings expert is her title. And so what she did, and you're going to hear from her as well throughout this case about her process as well, you're going to hear that Ms. Crawford tested this firearm and found, despite it being a very old firearm, that it was fully functional. It was working just fine. It was capable of recycling rounds through and firing bullets. But the other thing, and this is perhaps even more important than the fact that the Luger was fully functional, Ms. Crawford took 2 projectiles that we recovered from Carlos. The one that came out of his head from the autopsy, and then the one that was found under him in the tarp where his body was discovered at the apartment complex. She had both of those projectiles. And then she had, in addition, her own library of ammunition that she had in the lab as well. So she test fired the rounds that she had from her library of ammunition, and then she compared those rounds with the 2 projectiles that we know went through Carlos. And what she found and what she's going to testify to is that both projectiles bear markings that are similar. And when a gun is recycled through a firearm, through the barrel of a firearm, it leaves certain markings so that you know that it came from that particular firearm. Never has it happened in the history of firearms that a bullet has bared the same markings, and she will tell you this, that came from 2 separate guns. So the bullets that we pulled out of Carlos came from the weapon that we found in the defendant's trunk of his car. But we're not done, because not only did the police send the gun for testing, they also swabbed the gun for DNA. And they sent the they sent the DNA swabs that they tested, and they also had Mr. Lychwick's DNA as well. That was obtained pursuant to a buccal swab as well. They sent that to the lab as well. And what they found, there was a DNA expert that actually tested this as well. And each person has their own DNA profile, right? The only exception to that is if you have an identical twin, which is not true in this case. Mr. Lychwick's DNA profile was found on that murder weapon that was in his truck, or it was in his vehicle, excuse me. And what you're going to hear is that it was a single source DNA profile, not a mixture where multiple people are contributing to this profile, but a single source DNA profile. And that the lab's conclusion was that there was very strong potential for inclusion, that Mr. Lychwick's DNA was the profile that was found on that murder weapon. That is the highest support, that you will have the highest probability of standard that the lab has in terms of DNA. And the DNA expert will explain more to you this as well. We also, as part of this investigation, obtained Mr. Lychwick's phone. We wanted to see what he was searching on his phone. People search for all kinds of things on their phones, right? And we found some very incriminating searches on his phone as well. First and foremost, a brief just housekeeping matter regarding the email address. Conrad Lychwick, you're going to hear a testimony in this case that although the defendant's legal name is Kevin, he prefers to be called Conrad. In fact, you're going to hear that he would correct people when they would call him Kevin rather than Conrad. So not only do we know that this is his phone, because we wrote a warrant and were able to look at what he was searching, we also know that that's his email address. And so that was associated with his phone as well. And what we found when we looked at his phone was some very suspicious findings. 1 week, just 1 week after Carlos was never seen again, was never heard from, we have the defendant searching carcass movement, processing and disposal. How can I dispose of spoiled food safely? Large plastic bags and where to find them. Maps of landfill in Wisconsin.
Where can
this
I get
is
a
very
large
suspicious,
plastic bag?
and from the state's perspective, we believe the evidence will show that this is because he was making certain measures to see how he could dispose of Carlos's body after he had killed him. And there were additional certain things on his phone that were incriminating as well. November 25th, 2024, he went to Google. His phone went to Google and searched Waukesha News for November shooting. There had been no shootings in Waukesha County at that time, and we hadn't made public the fact that Carlos's death was by virtue of a shooting as well. Once again, much like the comment that he made during the execution of the search warrant at his house, only the killer would know this sort of information. So, ladies and gentlemen, There's 2 counts, as Judge Moss just explained to you. There's first-degree intentional homicide, and then there's the second count of hiding a corpse. I'm not going to spend a great deal of time on this as well. You'll get the full jury instructions at the conclusion of the case at the evidence, but I just want to just define a couple of these terms for you as you listen to the evidence. So the term cause, the first word in that, means that the defendant's conduct was a substantial factor in causing Carlos's death. Well, the evidence is going to prove to you that he shot him twice. Shooting somebody twice, once in the face area, pretty obvious, right? That's going to cause somebody to die as a result of that. And then intent to kill, again, you have the mental purpose to take the life of another human being, or you're practically certain that your conduct is going to cause the death of another human being. Again, I've already touched on this. We have the notes from the apartment talking about operations and neutralizing specific targets. I didn't use the word motive, and Judge Moss already explained this to you. I'm not going to repeat that. Motive is different from intent. We have to prove intent to you, but we don't have to prove motive. Now, that's stated more simply, we don't have to prove why he did it, but we have to prove that he did it and he acted with intent. And you'll get a jury instruction on that as well. And then we have the second count of hiding a corpse. You see the elements up there as well. You're going to hear from Detective Stern in this case. I've already touched on this about the location of the pile that had Carlos's remains in it. You're going to hear that it was Detective Stern's conclusion that that pile was deliberately set there. We will show you a number of pictures. You'll be able to see that there were twigs and other things and branches and things over top of this pile, almost as if the individual who put it there did not want this pile to be found. And again, we'll show you evidence on that as well. And again, the fact of the trail cameras that I've touched on earlier as well, the fact that the defendant was seen walking around in this area at very odd times of night, okay, when there was nobody out, again, evidence of that as well. So that's the second count. And finally, ladies and gentlemen, I'm going to conclude with this. You're going to hear from a number of witnesses. You're going to hear from police officers. You're going to hear from specialists. You're going to hear from eyewitnesses. You're going to hear from people who worked on this case. We have a DNA expert. We have a firearms expert. We have a medical examiner, a cadaver dog expert, a botany expert, and even a forensic anthropologist. So this is going to be a lot of experts that's going to come in and testify. The evidence is going to show that this investigation was not a rush to judgment. This was not a giant conspiracy. This is not an attempt by the Waukesha Police Department to railroad Mr. Lychwick. The police put a lot of time and a lot of effort into this case, and it was ultimately the conclusion that they had by following the evidence that Mr. Lychwick was the individual who was responsible for murdering Carlos in this case. It's the conclusion that is only supported by the evidence that we're going to present to you. And as we were sitting down and thinking about what is the most, proper or perhaps the best framework to present this, we came up with the idea of a puzzle. When you sit down to do a puzzle and you put the first couple of pieces in this particular puzzle, you may not be able to see, the full picture of the puzzle. But as you add pieces to it, and in this case, the pieces would be the evidence that we're going to present to you, and you hear more and more about the evidence that we have and how we present it in, then you start to see the bigger picture emerges. The puzzle starts to come in full focus. And that's what this case is. So Googling, for example, how to dispose of food safely, spoiled food safely, may seem pretty innocuous. But when you consider all of the other evidence that we're going to present, what it is it shows, it's one more piece of the puzzle showing that Mr. Lychwick is the individual who's responsible for the murder in this case. And I'll leave you with this. When you've heard all this evidence, and we've had an opportunity to address you in closing, and we're going to come before you and ask you to find Mr. Lychwick guilty of both of these serious counts in this case, I want you to keep in mind all the evidence that we're going to present to you. Because for all this evidence that we're going to show you, and I haven't shown you everything, right? We've just shown you some of the most compelling pieces of evidence. For all this pieces of evidence to be true, and for Mr. Lychwick not to be the individual responsible for murdering Carlos, he has to be the unluckiest man in the world. Thank you very much, ladies and gentlemen.
Thank you, Attorney Tombasco. Mr. Lychwick, would you like to give an opening statement at this time?
Yes, I would.
All right, you may proceed.
Ladies and gentlemen of the jury, quite simply, I am not guilty of this crime. I feel sorry for my poor neighbor, but I did not know him well enough
to kill him,
to have any animus against him even, and I have never killed anyone in my life. The largest warm-blooded animal that I've ever killed was a skunk that walked in front of my car by accident years ago.
I still feel bad.
I am not a killer. The police in this matter have a largely circumstantial case. I don't know how exactly they circumvene on me, but I simply did not do this. I am unprepared for this trial. I am in poor health. I was in poor health and doctoring at the time that they arrested me, and they knew that. The police have made gross exaggerations in their reports, and I do not recognize that firearm. This is the first time I am seeing a picture of the firearm used in this murder, and I do not recognize it. That was not in the trunk of my car when they stopped me. They did not have a warrant when they stopped me.
Objection.
The objection is overruled at this time. The warrant was discussed in the state's opening. Mr. Lychwick, though, I will remind you that you're venturing a little into argumentative territory. So I want you to just focus on what you believe the evidence will show, and you can infer arguments in your closing arguments, okay?
All right.
Go ahead.
I caught some gross exaggerations immediately with the prosecution's opening statement here. They're telling you that Detective Stern had presented me with a copy of the search warrant, which he did when they went and destroyed my apartment. And in the search warrant, Mr. Carlos's name was on the search warrant. And I knew everyone in our building there, down at the bottom of the hill here, knew that Mr. Carlos was being looked for, that he was missing. Detective Pavlik of the Waukesha Police Department took an initial statement from me the night that they were examining the crime scene when I was returning from a social engagement. I gave my statement to him, and he asked me if I had seen Mr. Carlos around anywhere recently, and I told him, of course, that I had not. This is a gross exaggeration. I don't know how the detective can wear his badge with honor and blow something like this out of proportion and use this as an excuse to center on me in this affair. I was never walking around in the area where the poor man was found. I was never in that area. And yet the state is telling you that I was walking in the area where the poor man was found. I was not. I was never in that area.
We'll be the
quite
judge
the contrary. The man who discovered the body and was an initial suspect of this crime, Mr. Polly, who is now missing.
Objection, relevance.
Mr. Lychwick, I'm going to sustain that objection. I'm not sure how the testimony is going to come out regarding that, but I think that's something that's outside the scope of this trial. So I want you to focus on the evidence that will be shown in this trial. You may proceed.
Mr. Polly is missing?
I would like to say that Mr. Polly was the one who was...
Objection.
I don't know what his next statement's going to be. What were you going to say, Mr. Lychwick? You want to say that Mr. Polly is...
Mr. Polly, a very suspicious character in this building to begin with, was seen quite frequently in the area where the poor man was found, where the remains were found of this poor man.
Hang on one moment. Attorney Tombosco, are you objecting to that statement?
Absolutely.
Why is that?
Because it's contrary to this court's pretrial rulings regarding Denny evidence.
Mr. Lychwick, I'm sustaining that objection. At this point, I want you to focus on the state's opening, your opening, the evidence that you believe will be presented, and I'm reminding you of the scope of some of my pretrial rulings about what can come in and what cannot come in into evidence. You may proceed.
All right. How many times has he been educated about the law?
In my defense here, you know, the prosecution is maintaining that Mr. Lefebvre's camera captured me walking around in the area that I lived in. I had reasons for being out the few times that I went out at night. As anybody, I'm living in a wilderness area. We're not allowed pets in my buildings. I put food out for the rabbits. I carry a rake to clean up the area under the tree where I leave the lettuce rinds that I give the rabbits.
Lettuce rinds?
I also curious as to where the local possums that are supposed to hang out in our pine trees live. And
skunks.
I was accused by the prosecution here of carrying a firearm when I was out. As you'll see in the videos that Mr. Flauber took with his trail camera, that is not a firearm, and it has been recognized as not a firearm. And if the state maintains that it is, I will object to that because it is a flashlight in an old camera case on my belt. I did not walk around with a pistol. I did have a pistol in one of the bags that they found during their illegal car stop, and it was
Objection. The objection? Again, he's violating the court's pretrial ruling.
Okay. Mr. Lychwick, there were motions heard before the trial about legality and illegality of any searches. The court has made a ruling that the searches in this case were valid and they were constitutional. So I'm not going to permit arguments that the searches were not legal. You may continue.
Is that the third? Is that the third
Well,
objection?
the police did not have a search warrant at the time that they took my car.
Objection.
Again, that, Mr. Lychwick, is something that would be ruled on pretrial. It's not a trial issue for this jury to determine whether or not there was a warrant present. You may continue.
We'll just count objections. How many are we at? 5 now? I think it's 5 objections.
Oh, I'm up against a lot here, ladies and gentlemen of the jury. I am a God-fearing man. I'm telling you, I did not know the poor victim. I did not even know him to where if I saw him in a store or he saw me, we would have said anything to one another. It is a 16-unit apartment building. We have multiple people living in each unit, and I have my lady friend, and I spend a lot of time away from my 16-unit building, doing my own business, minding my own business. We all are good people in that building. We mind our own business. As I told the Channel 4 reporter who interviewed me shortly after Mr. Carlos was found, and this whole thing blew over. And as I told Channel 4, Leslie Clough of Channel 4, who interviewed me, this whole thing was bizarre. Right around Halloween, they find the poor man, and nobody heard anything or saw anything. It was just bizarre. And as I told Ms. Clough, we're all good people in the building. We mind our own business. We're on different schedules. Again, as far as me and the victim go, I really never saw him that much. The closest look I've ever had of him was at the picture they just showed on the screen this morning. There was another misstatement made by the prosecution, and
I can see why you fired his lawyer.
The prosecution is maintaining that that I wrote some that they had evidence of the victim's name in my apartment written on a piece of paper. That is totally false. I had nothing at all with the victim's name on it. I did not know the victim that well. I'm sure he was a very nice man and everything, but I would have liked to have known him probably, but I simply did not. We were all on, I say again, different schedules, moving around on different time frames and timelines. I am acting as my own defense because...
Objection.
Sustained.
Mr. Lychwick, I don't know the jury needs to know the reasons for that. It is your decision to make. You have exercised your right to represent yourself. The court has granted that request, and that's the end of it. The reasons for that or behind that is not anything the jury needs to consider.
It was an excruciating decision, Your Honor.
Mr. Lychwick, that's not anything the jury needs to consider in trying this case. That's not for the jury to consider in their deliberations, okay? So move on, please.
Well, I enter these proceedings under protest as well, because I am not an attorney, and I have no access to my assets right now, and I had no access to
We're under protest now.
Telephone or computer.
Judge, I'm objecting to this. I don't see the possible relevance to the evidence.
The objection is sustained. This is all not relevant, Mr. Lychwick. You are in court now representing yourself. You are held to the standards of an attorney. And you, if you have anything else regarding what you anticipate the evidence to show in this case that's relevant, you may present that.
I have developed
Remember in the beginning,
evidence through the
when we started
discovery
110 years
process
ago?
in this case that strongly will prove that the Waukesha Police Department, namely 5 to 7 of these officers and detectives involved in this case, have compiled this evidence on their own. That they have falsely introduced this evidence against me. It is not just. It is not legal what they are doing. I came across hard evidence of their abilities and their intents and their lack of ethics when I received discovery evidence in the form of Axon body cameras from the night that they took my car on 1st December 2024. I found that there were sections missing from the body camera footage, including audio sections that were reworked and redubbed. I have not been able to get the state public defender to provide for the minimal cost to analyze the footage and the audio section of the footage to prove my point and to prove tampering and tainted evidence in this case, which should have resulted in this case being thrown out at least 8 months ago. It should not have come this far. But I have not been able to get my only source of defense, which was the State Public Defender's Office, who I took at face value, owing to their title, to provide me with the minimal, like I say again, the minimal amount of cost to develop the evidence, which is a very cost effective and relatively easy method that an amateur could process this evidence and show from the body camera footage and pulling it apart on a video editor, which is present on any computer. The fact that the Waukesha Police Department had doctored this film footage and doctored the audio portion of the film footage. What they cut out was the fact that they bumbled the car stop. It was completely contrived. As soon as I was pulling into the gas station from Appleton, Wisconsin, where they followed me apparently, they stopped me at the driveway of the gas station, and Officer C.D. Baca exiting his police cruiser along with Officer Tyndall trip over each other and start laughing. One says, "Stopped going 35 and a 25," and they start laughing. And the other one says, "Stopped going 35 and a 25." And they cut that out. And then I was offered a ride home when Detective Stern over here offered me a ride home because he said he was going to seize my car and have a warrant typed up at the police station so they could search the car. And I accepted the ride home down the hill from the Quick Trip gas station here on Pewaukee Road because it was quite cold and I wasn't feeling well. And Officer C.D. Baca of the Waukesha Police Department offered to take me home. And we made I tried making some small talk with him in the police cruiser. I just asked him if he'd catch any of the football games on recently or anything. And then when he let me out of the police cruiser in my driveway, which was dark and foreboding at that hour, being winter going towards 6:30 in the evening, Officer C.D. Baca did proceed to threaten me. He stated that I had better back them up on the fact that they're stopping me for speeding, going 35 miles an hour in a 25-mile-an-hour zone, which, by the way, does not exist on Pewaukee Road in the area where they stopped me. And I looked at he was standing in the shadows with another officer behind him who also pulled up in a police cruiser in my driveway. And they were holding on to their pistols. They had their hands on their pistols in a threatening manner. And I didn't know what was going to happen. And I looked at them, which you'll still see on the body camera footage if they show it, my reaction to C.D. Baca's threats are, yeah, all right, God. And I just wanted to get out of there and get into my apartment at that point. That they left into the body camera footage, but otherwise they have me saying, sure, the words coming out of my mouth were not those that I actually stated that night, which is tampering with the evidence, which is fraud. I was made to say, as you'll see on their version of the body camera footage, definitely, I agree with you. You know, have a good night and all this kind of stuff. That was not in the original Axon body camera footage filmed that night by the two police officers. That is tampering with evidence. I have tried to bring that before the court. I wanted to. I have the chain of custody of that evidence here, which shows considerable attention to Officer C.D. Baca's Axion body camera footage and Officer Tyndall's body camera footage. I can show that according to the jargon used with digital technology now, they call the data acquired by the filming and the audio portion of any body camera footage. And indeed, many of the footage that we ourselves are prone to photographing when we use our cell phones and everything is called checksum data. And in the evidence that I have in my disposal, which was presented to me on discovery by the prosecution and the police, I'm assuming they didn't think that me and my defense would come across this, but I did. And it clearly shows that they have changed this checksum data at least twice on C.D. Baca's body camera footage. Again, I strongly urge the jury to consider the tampering of evidence in this case. This case should have been dismissed at least 8 months ago when I discovered this evidence, which was given to me late by my first state public defender attorney who was grossly inadequate and not providing me the correct defense that I needed, and I was forced to terminate him as my public defender.
Oh, yeah, just don't leave it at terminate him. That's what you're charged with right now.
I emphatically deny any involvement in this crime. I am a law-abiding citizen. I am a good Christian of the Lutheran faith. I am a responsible citizen. I am an ex-police officer myself. I served as a security police officer in the United States Air Force.
I think he's winding down.
If this trial proceeds
as it's doing
in a manner which should deny me the justice that, in large part, I am really not qualified to oversee, as I am not a trained attorney, this will be a travesty of justice. I ask
And
you
then
to
moving for
please
mistrial, what?
consider the fact that a serious wrong is being perpetrated here. It will serve nobody if the state and the police, the several police officers of the many good police officers in the Waukesha Police Department have their way here. For one thing, the victim and his family will not receive justice.
You've got to pull
and
up
they
right
should
now.
definitely receive justice. The killer or killers, in my personal opinion, I think more than one person was involved in this homicide.
Objection.
Mr. Lychwick, consistent with the court's pretrial rulings on Denny evidence, the court will sustain that objection. It's also, well, the court will sustain the objection. Anything else, Mr. Lychwick?
Well, yes, Your Honor. Is that Denny evidence?
Yes.
It's something to Google tonight, sir. This is a train wreck.
And I must ask you to consider the fact that a person is considered innocent until proven guilty in this country. And I certainly am not guilty of this crime. And if the travesty of justice is allowed to take place at the culmination of this trial, the perpetrators of this crime will be allowed to roam free and perhaps kill again. You should consider that. The police should be put on the track of whoever did this to this man again, because while I'm in custody here, the state is under the false impression that they have their man, if you will, and they're not looking for the killer anymore. That is a serious miscarriage of justice in itself. That is a serious safety issue for public at large. I ask you to please weigh that in here as well. Ladies and gentlemen of the jury, I ask you to do your best, and I thank you for coming today and doing your duty as a citizen. I would have done the same thing. Thank you.
Thank you. All right, ladies and gentlemen, I will remind you that opening statements are not evidence. At this point in this case, you have heard exactly zero evidence. There is no evidence in this case yet presented to you. The only thing that's been presented is opening statements, and those are not evidence. So as you take a break for lunch, I will caution you to not discuss this case amongst yourselves. Don't come to any conclusions yet. You can certainly call to loved ones and check in and just state that you got selected for a jury. This is the trial you're on. But otherwise, don't say anything about the case so far or this process. Also, do not seek out any information on social media or news or Twitter or X or anything like that while you are on break. It is 12:27 right now. I want to give you time to take a break and get lunch. Let's reconvene at 1:40 p.m. and we should be ready to start the evidence at that time.
All right, so
all right, the jury.
They're going to go to lunch. We're going to go to lunch. I'm actually prepping for the caviar dish by tasting some Lay's potato chips without caviar right now, so I'll have it established in my mind what they're going to taste like with caviar. Whoa! Like major. This is crazy. This is crazy.
You may be seated.
Yeah, let's go back. Let's see if he's got anything.
We are now outside the presence of the jury. Mr. Lychwick, I just want to caution you on one thing. You made the statement that you are here in custody. Great efforts are being undertaken here to make sure the jury doesn't consider the fact that you're in custody. So it may be beneficial to you if you try to refrain from making that known to the jury. I know the state probably was on the verge of objecting to that, but didn't want to call undue attention to it, and I didn't want to interrupt and cause undue attention to it. It seemed more of an offhand comment, but nonetheless, it is for your benefit and your protection during this case to not have the jury know that.
Your Honor, I think it's an important facet of this case because it shows the fact that it's part of the fact that the reason why I'm having trouble defending myself and don't have counsel and am so unprepared to defend myself.
And it's not. It's not. It's not anything the jury is to consider. It should not sway their decision one way or the other, whether or not you're in custody. And you are your attorney, and you are held to the standards of an attorney. And whether that attorney is well prepared or not prepared at all, nonetheless, the trial's going. So that is not to be considered by the jury either. Any further statements about your preparedness, this being a travesty of justice, you not having sufficient time to review discovery, things like that, I'm not going to let that go any further. That's not relevant for the jury. It's not evidence, and it has no place in the trial. Understood?
With reluctance.
Okay. We are adjourned until 12:40. Anything else from the state?
I would also ask that the court admonish Mr. Lychwick to not make any more statements regarding his prior counsel being ineffective. That's quite frankly his opinion. There has been no finding by this court or Judge Shaneborn for the time that she presided over this case that any counsel has been ineffective. And so I think that is completely inappropriate for Mr. Lychwick to be arguing that as well.
Attorney Thompson, Attorney Jones withdrew at the defendant's request, correct?
That is correct.
Okay. So, Mr. Lychwick, I think that's a fair point, too, that the state makes. Both of your prior attorneys withdrew at your request, and you've made the decision to represent yourself. So calling your prior counsel ineffective or saying that or implying that the public defender's office hasn't met your needs, things of that nature are also irrelevant, too. And that goes to the court's finding that you are competent to represent yourself, and I granted your motion to represent yourself. That's as far as it goes. All the jury needs to know is that you're representing yourself pursuant to the Constitution. All right, we are adjourned until 12:40.
There you go. So now we get to go to break. It's going to be interesting. I'm not sure if we're going to get there. I'm not sure if we're going to get all the way to a verdict in this one. It's only supposed to be a few days long. It's a train wreck. We've heard everything. I think that Mr. Lychwick, can never get his name right. I think we've heard everything he has. We got all of it. Red panel, take a look at it. Looks awesome. I'm sure. I haven't looked yet, but I'm just speaking from the future. We're going to go to lunch, and we're going to come back with part 2. So I know we just started here a couple hours ago. That was my fault. But we're going to come back with... let me pull up the link here really quickly, Red. Let's see, home, switch to Red's team. Wait for it. There we go. Is that him? Are we sure that's him? Good. I think that's him. We have seen some innocent pro ses. We saw one down in Judge Clark's court in Florida, Panhandle of Florida, where he was tried for drug possession. The officers on body cam found a bag full of cocaine in his pocket, and the jury found him not guilty. So we've seen a couple, but all right, we've got this pulled up here. Let me make the new one here. Wait for it. We're calling this the hidden body murder trial. Body was hidden for 5 months or so before it was found, which is just crazy. All right, hang on. So part 2 will come to us. He said at 2:40 they're going to come back Eastern time. That's in about an hour from now. So let's turn that on, and this on, and that off, this on, and come back at 2:30-ish. Okay, just building the portal. Couldn't do this before he had told us what time we're coming back for lunch. I could have, but it would have been confusing, so. Glad we have a little case to follow. We might also be jumping to catch up with another trial that started out of Florida. We're just waiting for some clarification from the judge on that one, who has apparently ruled that we can't have live chat if we stream the trial. And live chat's sort of important to us. So we're going to try to get clarification and see if there's a way around that or understand a little better. Let's see. There's our afternoon. Oh man, Red, I forgot to, I haven't put the thumbnail on there. All right. Either way. It is what it is. I'll get it fixed. Thought he had counsel to advise. He has elbow counsel. Apparently he has not checked his elbow yet. Didn't look like he's talked to him at all. Waukesha is in Central Time. So we're coming back in an hour. They have an hour lunch. Eastern Time, that's 2:40 or 2:35. Somewhere around there. I need to express my snark or I will implode. I know. And I need your great input. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again in about an hour with part 2. We've heard the openings, now onto the evidence of this pro se murder trial out of Wisconsin. We'll see you guys after lunch. Bye-bye.
You're talking about stuff that